This topic is, or this session is entitled, Do No Harm, How Global Businesses Can Be Agents for Sustainable Development and Community Building. We're going to build off of the great discussions we've already had this morning. In fact, I think things are flowing really well. This is going to look a little more broadly at the role of businesses in both sustainable development and community building. We often think of businesses as having a significant role in developing regions and in reducing poverty and even in helping to reduce conflict. But we know that the reality has shown that this assumption is not true, it's deeply flawed, and that there's a broader role for businesses. Businesses in many instances have to help build trust with the various stakeholders, as well as have roles for additional governance capacity in local communities to really have a positive impact. So this panel is really going to discuss how can businesses positively impact local communities and regions by focusing on a number of different issues: stakeholder management, human rights issues, environmental justice, and sustainable development, particularly in those regions where businesses have not entered the market to sell to local consumers, so they're not as active as they should be. So we'll discuss what works and how businesses can avoid doing harm and even exacerbating conflict. So we've got a great panel. We have had some changes to the panel. Unfortunately, Leonardo Sempertegui, who is the General Legal Counsel for OPEC, just of course with everything going on with the G7 meetings and other things, was unable to make it. He had a last minute emergency and is unable to make it. And similarly, Professor Diane DeSerto, who is a professor of law at Notre Dame, was also unable to make it, but we've still have some great panelists who I will introduce. I will first introduce Lisa Sachs, who is the director of the Columbia Center on Sustainable Investment. Since joining the Columbia Center for Sustainable Investment, or CCSI, in 2008, she's established and now oversees CCSI's robust research portfolio in its cross-cutting areas of expertise, and has overseen advisory work around the world, including Chile, Guinea, Malawi, Mozambique, Namibia, Tanzania, among other countries. She also teaches a master's seminar at Columbia Law School and Columbia School of International and Public Affairs on extractive industries and sustainable development, and lectures at Externado University in Colombia on international investment law. She has served on the World Economic Forum Global Future Councils on international governance and on mining and metals, and is the co-author of the UN Sustainable Development Solutions Network thematic group on good governance of extractive and land resources. Before joining CCSI, she worked at the Interfaith Center on corporate responsibility and at Amnesty USA, in both cases on issues related to shareholder engagement and other issues. She has a bachelor's of economics from Harvard and earned her Juris Doctorate and a master's degree in international affairs from Columbia University.
Oh, and Diane has been able to join us.
Yes, it looks like Professor DeSerto has also joined us, so we're so glad you could make it. I will also introduce you. Professor DeSerto joined the law school, Notre Dame Law School, in January of 2021 as professor of law and an LLM faculty director with the joint appointment at the Q School of Global Affairs. She teaches, publishes, and practices in the areas of international law, human rights, international economic law and development, international arbitration, maritime security, and Association of Southeast Asian Nations Law and Comparative Public Law. She is a member of the expert group of the United Nations Working Group on the Right to Development resource expert for the Association of Southeast Asian Nations, former director of studies and faculty at the Hague Academy of International Law, president of the Friends of the Hague Academy Foundation, and Philippines focal point for the International Criminal Court Bar Association. She is active as an international counsel at matters successfully being litigated at the Permanent Court of Arbitration, the UN Human Rights Committee, the Philippine Supreme Court, and Southeast Asian agencies, and was appointed by the Philippine Supreme Court as Professor of International Law and Human Rights at the Philippines Judicial Academy. And then last but not least, Freddie Surgeons, who is filling in for Leonardo. He is probably, since his involvement, and he has spoken already, but he is the Robert Dole Distinguished Professor of Law and Director at the Washburn Oil and Gas Law Center. And I think we've already introduced him, but we appreciate his ability to sit in. He will bring a unique perspective because he is also the co-authoring a book with Leonardo on the international legal principles of energy transition. So with that, I think we can get started on what I hope will be a wonderful discussion on doing no harm. I want to start first, I think, with Professor DeSerto to provide some background on a number of issues. Professor DeSerto?
So my task here, at least for the next 8 minutes, is sort of to give an overview of where global business is moving on sustainable development. And what I've putting forward here is that there is a shift towards moving beyond the traditional expectations of ESG reporting or environmental social governance reporting for various reasons. And I'll discuss that in the course of this presentation. But needless to say, there is a growing convergence towards looking at what companies can do actively, not just to themselves respect human rights and environmental laws, and particularly be a partner in sustainable development, but also to see how they could also be a responsible stakeholder alongside government and civil society and communities in seeking to advance any of these objectives. What I see here, at least in legal developments, is that there is a shifting duty of care that we are seeing, whether it's in state regulations or in litigation or jurisprudence, which calls for a reinterpretation of respecting human rights in a much broader manner. What traditionally has been narrowly interpreted after the Ruggie principles as just the duty of a business to itself refrain from conduct that violates human rights in its business operations has in recent years been expanding steadily to include duties of prevention and not just mitigation and remediation for conduct that may violate environmental laws or human rights. So this is precisely why, when it comes to ESG strategies, it is not surprising that in recent years we've actually, especially more in the last 2 years during this pandemic in particular, where there's been a greater call to relinquish what is seen as a very outmoded and unresponsive set of ESG strategies. Up to this point, under the Ruggie principles, companies have more or less been devising their own ESG data, ESG indicators, or ESG scores. In investment management, this has been heavily criticized because of the very subjectivity of ESG indicators, because in the first place, the indicators are constructed without any reference to a set of common reporting standards. They don't necessarily benchmark human rights. They do benchmark what the companies think should be ESG, but that's not necessarily tied to the expectations of what environmental justice and human rights require. Also, there's a question about looking at ESG from the investment standpoint as more like a new corporate social responsibility tool that's just voluntary, instead of being able to adequately capture the risks inherent in the business transaction when it's done on a voluntary basis, not tied to actual international human rights law and environmental law standards. What we end up doing is underestimating risks that could afflict the business transaction. And so there's been a lot of criticism about the growing obsolescence of ESG and the data that's generated from ESG as to whether or not this is still responsive to the needs of companies who do want to undertake socially responsible investing, but are doing so in a manner that's quite untethered to actual international human rights law or environmental law standards. This is also happening in tandem with very recent developments on the global or at least on the perception of what global business should be doing by way of its duty of care. In the famous, highly contested case in Milieu Defensive versus Shell, this quote I've indicated here in the slide is quite interesting because it specifically says that in order to tackle adverse human rights impacts, measures must be taken to prevent, limit, and where necessary, address these impacts. This precise language on prevention and not just inherently refraining from committing conduct that could result in human rights violations has steadily been expanding our understanding of the duty of care. Needless to say, this case is still pending, but there is also a growing, at least catena of business and human rights cases, and I've only pointed to this as one of the examples, where the expectations of national courts appear to be that the duty to respect human rights must include very active duties to prevent. And this is especially operative in the environmental setting. I'm glad Professor Surgens is here, because when it comes to taking precautions, that duty to prevent has been strongly emphasized by national courts. So where are the parallel developments where we're seeing this expanding duty of care? In the United Kingdom, there's the famous case of Vedanta versus Lungoe, where the United Kingdom Supreme Court held that a parent company does have that duty of care and supervision and oversight with respect to its subsidiary regarding environmental and human rights abuses being committed in the extractive sector. In Canada, in the Nevsun versus Araya case, this is the first time that the Canadian Supreme Court said that business could be responsible for conduct overseas that violates international human rights commitments of Canada. And with the French Cour de Cassation, there was a recent ruling which upheld Lafarge-Holcim's indictment for complicity in crimes against humanity involving Syria. In the Inter-American Court of Human Rights, there's a Suriname, Lacogno versus Suriname judgment, which didn't only look to respecting human rights as part of the duty of business, but now also acting with government to protect human rights, which was a sea change from the 3 pillars that John Ruggie set up in the guiding principles on business and human rights. We also see this with respect to Germany's Supply Chain Act, which was scheduled to enter into force in 2023. France's corporate duty of vigilance, which again also includes not just refraining from conduct, but preventive duties, and the 2021 EU mandatory human rights due diligence directive, which is actually quite more expansive than the pillar 1 expectations of what a duty to respect human rights would be on the part of businesses. So we're seeing this convergence of parallel developments. On the human rights front, on the lawmaking front, we're also seeing in legal interpretations that increasingly look at the integration of environment, human rights, and development, and its applicability not just to states, but also to those who are acting in tandem with states. So in the UN Human Rights Council resolution of October 2021, there was a recognition by 155 states in the world that there is a human right to a healthy, clean, safe, sustainable environment as an independent human right that ought to be claimable, which is why there's some talk already about the possibility of this raising standing in various jurisdictions for individuals to be able to demand this as a matter of human right, not just from their governments, but also from private actors who operate within the territory and thus can impair or in any way affect that right. There's also part of what I'm a part of, which is where I am the chair rapporteur draft that helped to draft the 2022 UN Draft Convention on the Right to Development, which does have specific provisions on sustainable development, specific provisions on the protection of indigenous peoples, the duty that is held not just by states, but also by international organizations, as well as stakeholders, private actors. And when we look at development here, it's not just economic growth, but rather human rights-based development that is based on, consistent with, indivisible with, and interdependent with all other human rights. And that will also stand to affect the regulatory environment if it is passed this year, if not early next year. There is also general comment number 24 by the Committee on Economic, Social, Cultural Rights, which is the treaty body that administers the International Covenant on Economic, Social, Cultural Rights, affecting about 170 countries around the world. Now, in this general comment, which is the authoritative interpretation of the treaty body, states regulation of businesses is actively encouraged to ensure compliance with economic, social, cultural rights, recognizing that configuration in various settings, seeing that business is no longer just a passive actor when it comes to human rights, but must work in partnership with states to ensure compliance with economic, social, cultural rights, especially on housing, the adequate standard of living, on the right to water, on the right to social security, education, health, among others. So that said, and let me stop at this point on where I think global business can have participation and leadership roles. One is the traditional thing that global business has already been trying to do via its own ESG practices, try to regulate its own operational business practices, and to a certain extent, leave this to internal governance to comply with government standards. But this has problems, because if you're operating in jurisdictions where the government doesn't regulate enough to meet the international human rights law standard or the international environmental law standard, then it's simply taking advantage of the regulatory vacuum, right? You could be in compliance, but not necessarily complying with actual international human rights law or environmental law, simply because the government in the jurisdiction where you're operating does it itself include it in its regulatory fabric. And so much of the space of where the work has been done here in the last 10 years, including by Lisa's Columbia Center for Sustainable Investment, has been to try and reorient business towards that higher standard of international human rights law and environmental law. The second space where business has a role is, how does it work in partnership with governments to encourage and ensure respect for, and when we say ensure respect for, factoring in the duty of prevention, which somehow is now read into that duty of care, when it comes to human rights, environmental law, and development. Now, this space is not entirely clear. Public-private partnerships, as the panelists and the experts here very well know, are governed by multiple sets of laws and regulations. And to the extent that these laws and regulations, whether in project finance or in sovereign debt or in creditor relations, do not themselves internalize human rights, environmental law, or development, the right to development for that matter, then it becomes a contractual matter. Does the contract stipulate it? And if it doesn't, what is the duty for business to try and go outside the parameters of contract when it's not there in the contract itself? That would be quite countercultural to how business is expected to operate. This is also where, in the third space, where it's also where we see the biggest vacuum, there's been inroads in this role in how to work in partnership with communities, but it's also not been a fully fleshed out partnership, in the sense that when it comes to operationalizing human rights, environmental protection, or addressing poverty with human rights-based development, the question is the personality under which global business interacts with stakeholder communities, since they're not contracting parties, unless, say, it is expressly stipulated that they be a contracting party or a beneficiary to an existing project arrangement or structure. To what extent then can communities, not even taking into account the power asymmetry and resource asymmetry, to what extent then is there a real partnership when it comes to these projects? And the record is a little bit checkered in this regard. And I'm sure my colleagues can illuminate on many case studies we've had, where in some instances the partnership works, in some instances it doesn't. But let me stop here and at least capsulize where I think it's becoming inevitable to activate the second and the third roles, because we are now shifting away from a narrower definition of the duty to respect human rights on the part of business into something that includes the duty to prevent. I'll stop here.
That was a great background. Thanks so much, Professor DeSoto. Let's now move to Professor Surgeons, if you can maybe illuminate us even more based on the research that you're doing.
So I apologize that you don't get Leonardo Sempertegui, who is an absolute leader in the energy space as General Legal Counsel for OPEC, and have to make do with me instead. My hope is that I can nevertheless give you a sadly watered down version of his remarks, because I work with him on energy transition on a regular basis, including co-authoring with him. And let me jump off with a very simple proposition. If we want to realize human rights in the context of energy transition, if we want to tackle climate change and emissions mitigation, as well as adaptation, states are not in a position to do it alone. The financial demands that energy transition in the time frame that we have left impose upon us are simply beyond the means of any one style of actor alone, which means that we need to cooperate across the government, business, social communities, and local communities spectrum in order to achieve one of the largest challenges that we face today, which is energy transition. Now, this energy transition is deeply problematic from a development point of view, because it runs different development perspectives headlong into one another. And if you want to see how they run these imperatives headlong into one another, all we have to do is pick up a newspaper and look at the news from the G7 and look at the news about Germany's energy policy. On the one hand, Germany and the United States remain firmly committed to a strong energy transition pathway that is premised in significant emission reductions. On the other hand, in the current climate of energy insecurity, we are at a point where Germany is looking at extending the life of coal-fired power plants and undoing its nuclear exit at least until 2023, because one nuclear-fired power plant still has enough fuel to run until 2023 and is currently awaiting instructions from the government as to whether or not to shut down or to continue operating. So here we see a fundamental clash between environmental concerns as well as climate concerns, as well as energy security and energy equity concerns. And these energy equity concerns are critical if we look at the role of energy in our economy. Nothing in our economy works without equitable energy access. Business would grind to a halt. We couldn't have Zoom meetings. Bitcoin wouldn't be able to operate. These are all highly energy intensive forms of organizing ourselves economically. Just as importantly, we couldn't deliver healthcare, we couldn't deliver food, we couldn't actually meet the supply chain demands that we have today. So if you're looking at what is motivating Germany to step back on its commitments with regard to emissions reductions, coal exit, nuclear exit, it is precisely the understanding that rolling back energy access has massive problems from an economic point of view that would further be regressively felt in Germany, as well as other societies that would face the same imperative, because the poorest people would have the highest problem with access, would have to pay more of their income in order to gain access to the energy they need, which will be massively disrupted. So you see in this context how even in a developed country such as Germany, these imperatives clash headlong with one another. And you see this even more pronounced if you're going away from the global north and you're looking at recently industrialized economies such as Vietnam that will have a similar problem in the context of global energy transition as to how they're going to reorganize their economies. So you have here a need for cooperation across government, industry, and the civil society sectors in order to get this right. Now, the problem that you run into is that to the extent you want to do that, you're going to have to rely on extractive industry companies. It can't be done without it. To the extent that you want to electrify transportation, we've heard in the previous panel, you're going to need cobalt. Cobalt is mined, for instance, in the Democratic Republic of Congo under conditions that are not always human rights compliant, that create significant issues of environmental pollution. If you don't want to go to the electrification of transportation, you're going to have to develop oil and gas resources. Oil and gas resources similarly present significant problems from an environmental perspective as to how to build and operate oil and gas operations, how to integrate them into the community. And so there again, you see a problem that as we want to realize human rights big picture on energy transition, as we want to secure the right to a clean environment, as we want to secure a new international economic order that then builds off of that, we need to do things in the micro level that pit environmental concerns against social concerns, against human rights concerns. And as you look at this space, again, it can't be done without business, because it is the businesses that go into those spaces and that work with the government and sometimes with civil society in order to achieve as good an outcome as they're able to do, and sometimes don't act with any kind of responsibility, at which point you're then left with supply chains that are deeply problematic. So how do you deal with that? In my last couple of thoughts, and before kind of opening it further to discussion, handing off to Lisa, there are things that don't work. And the things that don't work are check the box approaches to community development and community engagement by extractive industry companies. Whenever they come in with a checklist and they say, we know how to do this, things tend to go badly wrong. They go badly wrong in projects that are financed by the World Bank under IFC performance standards. They go badly wrong to the extent they go under ESG standards from leading extractive industry companies. And they go badly wrong to the extent that they're just kind of built on a pell-mell basis. When do they work? They work to the extent that they take to heart the fundamental idea in the right to development in the treaty that is currently undergoing codification of the right to development. That development depends upon capacity building and engagement with the smallest stakeholders, with the most affected parties, and to bring them into the project, to give them ownership of the project, and to make the project part of their community. And in doing so, respects the rights not only of those in the local community where the project is housed, but also surrounding communities that are relatively impoverished by the presence of a large employer that only pays some people, but not others. That then in turn leads to social problems within the broader infrastructure and ecosystem of that social network. So We can only do it together. We can only do it to the extent that businesses step up to the plate and accept the human rights to development as the starting point. And we can only succeed in managing an energy transition to the extent that we all sign on to the statement that energy transition must be driven by human rights, and particularly the human right to development. And that is the work that Leonardo and I are writing on and are trying to push forward and to provide case studies as to how you do it right and how you do it not so right, where you could do better. So with that, let me turn it over to Lisa.
That's a good transition, I think, to Lisa's discussion. So Lisa, please.
Yeah, thank you so much. I had asked to go last so that I could, rather than prepare new ideas, be able to reflect on what Diane and Freddie had said. But boy, have you given me a lot to respond to. Also important and interesting, and so I won't be able to do it justice. But I do want to maybe start big and then drill down on one particular idea that I want to add to this discussion. One thing that I think is useful as a starting point, two things I think are useful as a starting point. One is that it's not new that we're talking about the roles and responsibility of business. And yet, despite a proliferation of sustainability reporting and arguably greater attention to the role that business must play in sustainable development and respecting human rights, the outcomes are worsening, I would say, not improving. We're facing as a world several environmental crises of climate change, of pollution of land, water, air, loss of biodiversity, social crises, of preventable disease, diseases of despair, one of the most overarching social crises of widening inequality within countries and across countries. And again, that inequality is widening even as we shine a spotlight on it. It's not narrowing. So we're facing real crises despite arguably greater attention to the responsibilities of non-state actors and of state actors. So we need to do something different. I am a human rights lawyer. I absolutely put the human rights framework as the center, but I want to add another framework, which is the Sustainable Development Goals, which I consider to be our generation's attempt to operationalize at least the economic, social, and cultural rights from 50 years ago. We're still trying to realize those rights. Now we have the Sustainable Development Goals, a set of 17 interrelated and specific goals that have been disaggregated into 169 specific targets that help us understand complex transformations that have to happen to realize the rights that we are all speaking about. I think it's helpful for companies, for all stakeholders, to really understand not just the individual sustainable development goals, but the holistic set of goals and the transformations that they imply. One of the things that we've set out to do at the center is to help companies understand holistically, and by the way, company stakeholders understand holistically how companies align with or don't with the sustainable development goals. I would say that one of the problems in our one of the problems that has contributed, I think, to the worsening outcomes despite greater attention is that we're not really looking at all of the ways in which companies impact on the sustainable development goals. And we've allowed, as Diane actually was pointing out, a focus on, or allowing companies and others to focus on some particular areas that they want to focus on, either because they're particular risks that they're managing or areas in which they're contributing, and not looking holistically at how companies are aligning. So very briefly, and then I will hone in on one particular aspect and then stop. Very briefly, we have put forward a framework suggesting that we should look at 4 aspects of company practices to understand to what extent they are aligning with or undermining the sustainable development goals. And those 4 aspects are the products that a company is producing, Are its products contributing to societal well-being? What are the impacts of the goods and services that companies are marketing today and plans to market in the future? A second is the environmental and social impacts of the production processes. What are the implications of avoiding such impacts? In the extractive sector, that's really a profound challenge because extractive industries are by nature extractive. So that is absolutely one of the core, but not only area to manage. A third is recognizing that businesses today operate in complex value chains, and to what extent do companies share responsibility with other actors throughout their value chains in how their products are used, in where their supplies are sourced from. We need to understand the role of companies in their value chains, not only in their specific part of their value chain. And then the fourth, which is the area that I wanted to dig in on for the purposes of this conversation, is how a company engages with citizens, lawmakers, and communities. I think this aspect is too often absent from an understanding of a company's responsible practices. Looking at a company's tax practices, their engagement in litigation, defensively and offensively, suing host governments for policies that impact their profitability, targeting human rights defenders, filing SLAPP suits, and so on. How are they using the law? And then most notably, and where I want to talk, and then we'll stop, is how companies engage directly or indirectly in lawmaking processes. Diane talked about a regulatory vacuum in which some companies operate, but one thing that we should note is that businesses have played a role in creating that vacuum. They continue to play a role in creating that vacuum. And that's the point that I wanted to emphasize with respect to a business's responsibility to do no harm. Markets will tend to externalize any social and environmental costs that are not regulated. Emissions, pollution, human rights violations, including labor conditions, data privacy in tech companies, the whole gamut. Companies frequently profit off of products and practices that are harmful to human and planetary health that are not regulated, allowing the companies and their shareholders to profit off of the costs that they're imposing on society. So we need regulation. It is the only way to steer business sectors on sustainable trajectories. It is the only way to avoid leakages. It is the only way to protect the most marginalized, the future generations, the planet, and so on. We need regulation to ensure that our economy does not contribute to growing inequalities, to these environmental crises, to the human rights violations, and so on. So we should be looking at what influences these regulatory processes. That to me is a central question. It's not incidental to the rest of this discussion because businesses know how central regulation is, know the impacts that that would have, and therefore often use their considerable power and resources to influence regulation. And by the way, in the energy sector, in my country, in the United States, the energy sector, the oil and gas sector is one of the most powerful, most evil in its use and its attempts to influence regulation. The amount of money, of revolving doors, of other means of both direct and indirect influence over lawmaking processes in order to protect the interests of the energy sector from regulation that would help to align any energy investments with our sustainable development goals. So maybe I will stop there and just really center the engagement of companies with lawmaking processes as part of a consideration of companies' responsibilities to do no harm. Stop influencing lawmaking processes. We need law to steer, to direct the engagement that Freddie talks about of how companies need to engage with governments. That's absolutely true, but we need elected governments who are coordinating at the international level, who are developing integrated policies at the national level, who represent the interests of communities, of the environment, of future generations, to set the pathways for responsible business conduct. And that should be without influence from the business sector that has very different interests from that of society. I'll stop there.
Wow, that's great. And then I want to allow each of the panelists to chime in. One of the questions I think that we've talked about before, and I think it may be helpful, is to sort of for the audience, make sure we are using sort of the same concepts and ideas first off, and that's understanding what is sustainable development. I know, Professor DeSoto, you mentioned before in our discussion that there is, real uniform definition, but that there might be a definition of sustainable development that could be useful for our purposes today.
Yes, so the traditional understanding, narrow framing of sustainable development has been needs-based, so that the use of resources today should not compromise the use of resources in the future by future generations. But that's actually quite a narrow understanding of sustainable development, because it is primarily from the lens of need rather than from the lens of an ecosystem and how to understand resource management and use and need in an ecosystem that has considerable interdependencies. The reason why our revised convention on the right to development emphasizes the consistency with human rights law is precisely because sometimes even there are circumstances when the use of resources in and of itself, I mean, you could be complying with the degree of supply for resources and preserving it for future generations, and still you could also be impacting the future enjoyment of human rights by future generations. So this is why in our draft convention, we've widened that definition to take into account beyond what's in the Brundtland report, but also in the many instruments, including in the Sustainable Development Goals, the understanding of interrelatedness. That's why when we take a look at zero hunger, zero poverty, but 169 targets in the Sustainable Development Goals, much of the language, by the way, we've also indicated in the convention, it's with a view to understanding the interrelatedness of how we consume, how we produce, how we generate activities, how we refrain from activities, and what those impacts are intergenerationally, not just for humanity, but for the rest of the planet. So let me begin with that. There's a narrow understanding that's just on resource use, but the broader understanding, at least in international human rights law, has moved towards not just resource use, but process, but also the understanding of what development is. Does it necessarily mean producing more things, making more things? There's also a cultural reference to how we understand development and who charts that development. Is it going to be, people in academia or people themselves who want to define what that development means for them? It means very different things. And I hesitate to say global south because there's large countries in the global south and there's really tiny countries in the global south. They don't all have the same interests. So a lot of this goes back to what Freddie and Lisa were talking about. How do we localize that? And to the extent that we try to map what we mean by development, there has to be, in the first instance, that drilling down into who speaks on what development is. And if business has a preponderant voice, then maybe that's something to talk about as well.
Lisa, I want you to enter, I know that the project, the CCSI project is focusing on, as you mentioned, 4 of those sustainable development goals. Is that definition, or is there a set definition within the context of the project that is different or related to what Diane mentioned?
Yeah, no, thank you. I love Diane's explanation and couldn't agree more. So no, I think we do often use the Sustainable Development Goals as our framework, which I don't think is inconsistent with what Diane is saying, although surely there are other important components of what Diane has helpfully said in terms of localizing those goals first of all, and how development pathways and plans, quote unquote, development pathways and plans, or what communities want for themselves, are defined locally. I think one thing I would just add, but again, not to be inconsistent, is that, not inconsistent with what Diane was saying, is that for sure, traditionally, the concept of development has been largely around economic growth, and it continues to be how so much is measured in terms of GDP and what economies are producing. Diane said this, but I just think that is one of the easiest, in a sense, wrong constructs to break down, that I think development is, even if we don't go into the granularity and the challenges of definitions, all of which I agree with, it is at its core about societal well-being and human well-being, however so defined. And we have other proxies for that we can use in the meantime. So we have measures of human happiness that don't correlate necessarily with GDP growth. Diane was talking about differences among the global South. Equally, there are differences among the global North in how countries prioritize the well-being of their societies, or what they consider to be well-being of their societies, and work-life balance, and all sorts of measures of well-being. And one reason I think that that's important is because, for sure, with our planetary boundaries, we cannot grow in terms of our economy and in terms of production of resources endlessly. And that has led to this concept of degrowth, and we need to slow growth and so on. I would say that there's actually no limit to improving human well-being. If we use a different measure of growth, if we're talking about growth in terms of improving human happiness, satisfaction, well-being, which can and should be grounded in local self-determined pathways, as Diane was saying, then we don't have to talk about degrowth as the only model to stay within planetary limits. We just are looking at a different measure of quote unquote development, or of growth, that seeks to maximize human well-being within our planetary boundaries.
Freddie, same question. I'm not sure if there's, in the issues that you all are looking at in your book and some of your other research, how does, how do these definitions of, or this, I would say it's the same definition of sustainable development, how does that fit within your research and energy transition?
So part of what, and I also wanted to reply to something that Lisa had said. Part of what the problem is that we're running into is that energy systems function very much as a commons, in the sense that they work cooperatively. They don't work when people defect from cooperation. And they pose a trilemma of access to a resource on an equitable term, in terms of affordable and directly available, as well as a security sense of, is it always going to be there when I need it? And then a sustainability sense. And part of the problem, so sustainable development in that context, is to keep governance going, to keep balance between the countervailing demands of the three limbs of the trilemma. Now, the problem that you run into is that you can only successfully manage energy transition or energy systems, period, to the extent that you have trust between the different stakeholders that are part of these energy systems. The moment that you have distrust between the various stakeholders, you start getting defecting behavior that is perfectly fine from a self-interested point of view, but starts harming the sustainability of the system as a whole. So to give an example of that, we currently see one of those moments where we seem to have massive cognitive dissonance. And we have massive cognitive dissonance precisely because this trust isn't there. Oil. On the one hand, we need more of it in order to stabilize prices. not more of it in real terms, but more of it in terms of actual availability to market. So on that side, we go to oil producing companies, oil producing states and say, hey, we need more, can you help us out? On the other hand, there is the problem of a hostility towards the sector that leads to a level of distrust. And let me explain in kind of what I mean by that. Assume for a minute that we were to increase oil production. It's not going to be something that is going to happen overnight. It's going to be something that takes a little bit of time. And the problem is that if everybody coordinated, well, maybe it might work, but we have at the moment an actor in Russia that is obviously not coordinating with us because we've imposed sanctions on it. So herein lies the problem. The market, the energy market, needs to trust that to the extent that somebody says, well, we would like you to produce more, that if there's an overproduction of oil into the marketplace because something changes, that overproduction will be compensated for. We're living in a world of what, 2 years and some months past negative oil. So if you're living in an environment where oil companies ran out of storage capacity, and people were laughing a little bit of like, look at them, nobody's sorry for them, right? To now saying, look, you got to produce more. You have this trust barrier. The only way that we can manage energy transition in the immediate term, or energy needs in the immediate term, is if we have greater understanding and trust between these entities so that they can act towards a common good. Now, that would require us to understand motivations and act on them in a way that moves a conversation forward. Yes, oil and gas interests have interest in regulation. They have an interest in increasing shareholder value. At the same time, the energy industry is central to what we do in this country. So one needs to find a way to say, well, okay, this shareholder value point is probably too much. They're bad actors in every industry after all. But at the same time to say, yeah, but we kind of do need you. So let's not push you back too far. So I think from a sustainability perspective, it really boils down to, can we work together? Everything we do on energy transition depends on, do I trust the government to keep its word on energy policies? Every time the government is seen as not keeping its word, you increase risk, you increase risk, you increase price, you increase price, you decrease availability, you decrease availability, you increase conflict. So that, where to me, is where we need to work.
I didn't know if there were any additional thoughts or
No.
comments.
It's really just, as we look at sustainability, sustainability depends on trust. And it depends on trust between these stakeholders, government, industry, civil society. And we need to repair that trust, because I think it has suffered.
So again, not to be devil's advocate too much, but to also use a statement that Leonardo mentioned in our discussions prior to this seminar. And he mentioned that energy companies have to become change agents for sustainable development. And I'm wondering, as both Lisa and Diane alluded to, there is a lot of distrust already in the market globally with certain energy companies. So how do businesses in general, but particularly energy companies, when you look at the Shell case and a number of other cases that focus on the energy industry, how can they become those change agents, and how can they actively rebuild that trust or build the trust?
I mean, to my mind, the answer is that we need to have engagement between these stakeholders, meaningful engagement. That's how you solve this problem. So, in so many ways, development gives you the answer as a procedural tool. And so that's where, to me, we really need to focus, is on not seeing it only through our own lens, but also seeing it through the other's lens. Because OPEC has whiplash at the moment. On the one hand, it's look, we need to phase out all fossil fuels by 2050 or else, in the run up to the Glasgow Climate Pact in the International Energy Agency Net Zero 2050 report. And now it's, you got to produce more. And this is within a time frame of months. So we need to figure out how to communicate that better so that you then get the better response, so that you then create change agents in a way that you want to create the change.
I actually will add to that beyond engagement, though, so that we know everybody is engaging in good faith. I would hold, and at least for me, the minimum requirement is that all decision makers, whether they be the public sector or the private sector, continue to have mechanisms not just for monitoring by civil society, but also for accountability. I mean, one of the easy things that we thought would have been easy was to get business to agree to binding dispute resolution procedures that give direct standing to communities that are impacted, instead of just, say, shareholders or investors in the project, right? That doesn't happen. And human rights victims have to play the carousel of, let me try and find a jurisdiction that's willing to take my case because I'm trying to enforce a judgment against a particular company that has transnational operations. One way to restore trust would be to make it easier for the monitoring to happen, not just to have meaningful engagement, but also to know that if there are business practices that do not comply with the expectations of human rights law or environmental law or the right to development, that we will resolve this dispute under law and provide that opportunity to resolve it, as opposed to trying to make human rights victims go around the globe trying to find a friendly jurisdiction within which they can seek redress. I mean, it's a long-standing structural problem. It is, to a certain extent, almost analogous to the kind of jurisdictional bars that states can impose when human rights victims try to sue them. They can always invoke sovereign immunity. With the private sector, they can always invoke some sort of jurisdictional territorial bar, or even, this is where the duty of care and the duty of prevention comes in. That shifting legal standard is important. We shouldn't be waiting for courts or for tribunals to say, companies, you have a duty of vigilance, you have a duty of care, you have a duty of prevention, you should be monitoring. There should be some way by which that responsibility down the supply chain actually becomes an accountable form of responsibility. But we still don't see that happening. So for me, apart from engagement, in parallel with engagement is engagement in good faith. Let everybody be an equal partner in this. It hasn't been happening, and I can understand why there's so much mistrust in that respect. But part of restoring that trust also has to begin with business recognizing that indeed it hasn't always acted in the way that people would desire. And so to the extent that you want to be part of this conversation or you want to be at the forefront of it, it also involves a necessary counterpart, accountability. And we see that in drips. We don't see that in droves. The more that I see it happening a lot easier for human rights victims than it does for foreign investors, then I'll be more inclined to say that's being a change agent for sustainable development.
Lisa, I know you have some thoughts. I can see, I can see your facial expression. So
I'll maybe say a couple of
in.
things. First of all, just to agree with Diane that means of accountability and remedy are core. And for us, they're in that framework I just wanted to mention. And the fourth pillar that companies, that part of the doing no harm is having, making it easy for affected communities and other stakeholders to seek redress. So that's one point. On the trust, Freddie, oil companies will have to work very hard to restore my trust, that's for sure. I think we have historical distrust with a lot of companies for good reason, and continuing distrust for good reason. And so I agree with you, but this is not stakeholders coming to the table on equal footing. Nor is it, I would say, in good faith, actually, because many oil companies are not coming to the table in good faith. Our planet and our future generations depend on the immediate phase out of fossil fuels. Temporarily meeting energy needs, first of all, that could be a whole other panel on what's needed, but it cannot come at the expense of a overdue, rapid, and complete decarbonization plan. And it is at the moment. So we're not actually having conversations on the basis of good faith and trust. And that's, I would say, a concern. But I otherwise agree with you, but I think that trust needs to be earned by the global behemoths that have not been a partner in development for decades, nor do they show a sincerity in being a partner in achieving sustainable development.
I want to encourage anyone in the audience, if you have any questions, to put them in the chat and I can ask the panelists. And while we're waiting on that, I do, in the interest of time, do want to touch on one other topic I think that we are broaching, and that's this topic of environmental social governance, or ESG. We've seen it in a number of different ways: CSR, sustainability, ESG. We're seeing, I think, not just in the United States with new regulations related to ESG disclosures and other obligations by several agencies, but we're seeing it sort of really across the world with what seems to me to be ESG on more steroids than, whatever acronym you use, than in prior times. I want to get the panelists' opinion on whether they think this time it's different and how it is different. And I know Professor DeSerto, Diane, you mentioned a little bit more of the focus on human rights, but do we think that this time it will make a difference? I don't know if I got cut off, but it'll make a difference on it this time with more global focus on it.
So let me respond briefly to that point. It's interesting, we live in a time when everybody has basically co-opted the human rights language, except people talk of different rights at the same time. So, whether it's states or communities or business or dictators or authoritarians, nobody is denying the salience of human rights. It's a question of trying to say that it's one human right vis-a-vis another human right, or my understanding of human rights is better than others. Which from an educator's standpoint is a good thing, because at least we all know everybody's inclined towards adapting that language of human rights. Is a question of how do we mediate discussions among us when we have healthy differences of view as to how to realize the right. The very same question on outcomes that Lisa was talking about earlier, right? The same question on the energy transition that Freddie was talking about earlier. My challenge with the ESG frameworks, as interesting as they have been, including when they have been formulated by the Big Four in accountancy, right, is that they've been quite selective. It's some rights, not all. It's some understanding or interpretation of rights, not all. And it's in tandem with that, you will not see an ESG framework that will carry with it the remedial mechanisms that are part of human rights law. So this for me is the longest standing gap. Not only is everybody, I think the phrase that they use now is greenwashing. At some point, I'd like to tell them it's human rights washing. Everybody likes to invoke the cloak of human rights, except you don't know what they're packing underneath it. My challenge here is precisely, if this is indeed about human rights, if this is indeed about environmental, social governance standards that are based on law, that in the first place are directly possessed by communities who are nowhere part of the business transaction, who are nowhere part of the government regulation, to what extent is there a real accountability mechanism for the very same parties for whom human rights was constructed? That's what I find so ironic, because we have such a proliferation of wonderful frameworks. There's a checklist framework. I'm part of a group that's designed we're presenting at World Water Week on how to ask the right operational questions on implementing the right to water, for example. And I purposely departed from how others have done it, which is to do this by indicator or by checklist, because I think it's actually a much broader conversation. It should be the kind of conversation that Lisa and Freddie and Daniela and I have been having right now. This kind of discussion of who's favored, what's the result, what's the outcome, where are the leakages in trying to realize the right, what other rights are interconnected. We don't find that in any single ESG framework. I've read far too many of the interesting, informative sustainability reports and came out of it thinking, well, it's interesting that's how they understand human rights. I mean, we talk about intersectionality in human rights law and the fact that who's disproportionately impacted, whether by race, by gender, by status, by sex, by ideological preference, any of the markers of diversity. And yet that doesn't suffuse ESG standards anymore. So where am I leading with this? I think it needs two things. And I said this before in my presentation. It needs going to the common vocabulary, the common binding standards, which is already found in international human rights law. And one thing companies can do is voluntarily agree that they are bound by it. I know that's a tough sell, especially since companies will agree to, for example, voluntarily implement the Paris Agreement, but they don't want to be accountable if they didn't actually implement it. The second part is exactly the accountability dimension. If we mean and we're serious about really doing this for communities, really doing this in a cooperative fashion, I should be able to trust that when you don't live up to your bargain, your end of the bargain, I have recourse. That's a basic guarantee of rule of law. And yet we don't have that. We don't have that. It's so variable, again, because ESG manages to human rights wash a lot of things. And sorry, I ran a little bit for that, but I'm going to turn over to my co-panelists.
I might have a fun, if slightly unexpected answer for you,
Okay.
which is that to the extent that stakeholders in a particular industry do what they have done, which is to put out statements that say that they will comply with human rights as part of their ESG statements. These statements in and of themselves become generally accepted practices within that industry. The moment they become that, they're actionable under the underlying production sharing agreements, licenses, concessions. So to the extent that states and state petroleum companies or state energy companies or state mining companies want to take energy companies at their word, they currently have the means to do so. The problem is that we have too few people who are able to run those kinds of arguments. But to a certain extent, where is the recourse? The recourse is that these ESG statements have become business practice. And the moment they have, they're actionable under every contract that these companies have signed, because they bind themselves, and most of them, to act as prudent operators, to act as consistent with international petroleum industry standards. And here's your standard. You didn't meet it. There's an arbitration clause that is there precisely for that. So there is a means that one can hold people accountable for it. And I would be curious to see what people in the industry would say when that claim comes, because to say this was just marketing is not going to work. For one, because it would be incredibly poor marketing. So at some point, we're going to get to see the opportunity to actually litigate these out in too narrow a set of confines, but certainly as a starting point.
Lisa.
We're likely out of time, but maybe just to add a couple things. ESG deserves its own huge conversation because there are so many challenges, but maybe three things to quickly say. One is that there's a lot of confusion over what ESG is measuring. Is it looking at the risk to the company? Is it looking at impact? The answer is it depends on the framework. Many ESG is just looking at quote unquote material risks. That's very different from impacts. Anyway, so that's one issue. A second issue is very much greenwashing. Lucian Bebchuk at Harvard wrote what I think is a fantastic paper looking at the Business Roundtable, who made commitments to a stakeholder model instead of a shareholder model, saying, oh no, now we're going to reorient our businesses towards stakeholders, which is essentially suggesting they'll operationalize certain ESG principles. And then when shareholders filed resolutions in line with those stated commitments, the companies in their no comment letters to the SEC said, oh, no. When we said that, we didn't mean we were going to change anything. We were just saying what we already did. And he has 40 such responses verbatim saying, no, this didn't actually mean we would change anything. So, okay, what did it mean? And why are you making those commitments? Which leads me to my third thing about ESG, which is that we have to be very careful that initiatives that relate to private sector reporting and voluntary commitments don't replace regulation that would universally apply. And there is absolutely an intentional movement and an unintentional one. I think in the case of the Business Roundtable, it was likely intentional, but in other cases, it may be unintentional, suggesting that certain types of disclosures or voluntary commitments and so on are sufficient to get us where we need to go. And the truth is that they're not. So we just need to be of the orientation, as has happened in other spaces, that these can be initial building blocks to get to the regulation, the more widespread universal regulation that's needed, not regulation related to the disclosure of ESG, but regulation to impose costs on harmful activities and liability for that type of harm. So as long as we are seeing ESG as a step toward identifying what types of harms need to be regulated and prohibited, I'm all for it. But I fear that we need some steering to get ESG back on that lane.
Yeah, I totally agree. Even with the 600 plus different standards, depending on what perspective you're looking at, it is definitely confusing, and a broader topic that we could touch on at another time. But I want to thank all of you for your insight, your perspective, and for a lively discussion on these issues.